Welcome to Innovative Things. Today we will cover part 2 of international agreement. In that, first one patent law treaty, second one is World Intellectual Property Organization, and third one is TRIPS agreement. Now before starting, here's a helpful tip to all the patent agent exam aspirants. The frequently asked questions covering key points for your preparation are available on the official website of the Indian Patent Office. Simply visit www.ipindia.government.in or go to Google and search frequently asked questions patent. These resources will help you ensure that you are covering all the important points for the exam. Now let's start with our today's class. First one is Patent Law Treaty. The Patent Law Treaty is an international agreement which is designed to make the process of applying for and maintaining patents easier across the different countries. And it was created by World Intellectual Property Organization in 2000 and became official in 2005. Objectives of Patent Law Treaty. First one, there are 5 objectives of Patent Law Treaty. First one is simplifying the process. The Patent Law Treaty reduces the complexity of the patent procedures, making it easier for the people to apply for the patents by selling common rules for all the member countries. Second one is consistency across the countries. It ensures that patent systems in different countries follow similar rules, so the process of applying for and managing patents is more uniform. Third one is flexible filing dates. The Patent Law Treaty allows applicants to submit incomplete applications to secure a filing date, giving them more time to gather any missing information. Fourth one is missed deadlines. Means if someone misses a deadline in the patent process, the Patent Law Treaty provides ways to recover or fix the situation under specific conditions. And last one, fifth one is online filing. The Patent Law Treaty encourages using electronic methods to file patent applications, making the process faster and more convenient. Next. What the Patent Law Treaty does not cover. First one is, it does not change the core rules of what can be patented or how patents are examined. Each country decides those details for itself. And second one is, it also does not handle how patents are enforced or challenged. Second one is World Intellectual Property Organization, WIPO. The World Intellectual Property Organization is a United Nations agency that focuses on protecting and promoting intellectual property worldwide. This includes things like patents, trademarks, copyrights, and industrial designs. WIPO was created in 1967 to help encourage creativity and innovation by making it easier for the people and businesses to protect their ideas in different countries. Next is objectives of WIPO. First one is global protection. Means WIPO helps people secure their intellectual property rights in many countries so inventors and creators can protect their ideas across borders. Second one is developing IP policies. WIPO helps countries create and update their intellectual property laws to keep up with new technology and global trends. Third one is registration services. WIPO makes it easier to register patents, trademarks, and industrial designs globally through its systems like first one is Patent Cooperation Treaty PCT for patents. Second one is the Madrid system for trademarks. Third one is the Hague system for industrial designs. These systems let you apply in multiple countries with a single application. Fourth one is helping developing countries, means capacity building and technical assistance. WIPO offers support to developing countries through training and legal help to improve their national IP systems. And last one, fifth one is solving disputes, dispute resolution. This helps settle intellectual property disputes like conflicts over internet domain names through mediation and arbitration. Next is important WIPO treaties. First one is Paris Convention 1883, which protects patents and trademarks globally. Second one is Berne Convention 1886, which protects copyrights internationally. Third one is Patent Cooperation Treaty PCT 1970, which simplifies the process of applying for patents in different countries. Fourth one is Madrid Agreement 1891 and Protocol 1989, which simplifies trademark registration internationally. And last one is Hague Agreement 1925, which covers the registration of industrial designs. WIPO headquarters. WIPO is based in Geneva, Switzerland and has 193 member countries as of 2024, making it one of the largest organizations dealing with the intellectual property. In short, WIPO helps inventors, artists, and businesses protect their ideas and creations on a global scale, making it easier to manage intellectual property across different countries. Last one is TRIPS. TRIPS means Agreement on Trade Related Aspects of Intellectual Property Rights, which is an international agreement that sets common rules for intellectual property IP protection like patents, copyrights, and trademarks across all World Trade Organization member countries, and it came into effect in 1995 and is managed by World Trade Organization. What are key objectives of TRIPS? First one is minimum standards. TRIPS sets basic standards for IP protection that all member countries must follow. Second one is balance. It ensures that protecting IP rights doesn't harm public interest like access to medicine and knowledge. And third one is uniformity. TRIPS makes IP laws similar across countries, making trade and investment easier. Next is main features of TRIPS. First one is wide coverage. It covers many types of IP including patents, copyrights, trademarks and trade secrets. Second one is patent protection. Countries must provide patents for new inventions for at least 20 years, though there are exceptions, especially for the things like medicines and agriculture. Third one is enforcement. TRIPS ensures that countries enforce IP rights, including having legal actions against IP infringement. Fourth one is flexibility for developing countries. Developing nations can take extra time to meet TRIPS obligations, and they can also use compulsory licensing in health emergencies, allowing them to produce generic versions of patented drugs without the patent holder's permission. And last one, fifth one is public health. The Doha Declaration 2001 clarified that countries can prioritize public health over patents, ensuring access to affordable medicines. And last one is role in public policy. TRIPS aims to protect the interest of IP holders like inventors and artists while also addressing public needs such as healthcare and education, and it's often debated, especially when it comes to balancing IP rights with the need for affordable medicines and the protection of traditional knowledge and biodiversity.